everybody. This, as always, is a legal update, meaning I'm going to tell you about the latest legal developments. And at this time of year, that mainly means new laws, because the governor just got finished a couple days ago finishing all the new laws that are going to happen this year. So there aren't going to be any more new laws this year unless there's some emergency or something like that, which I don't see happening. I'll also talk a little bit about forms, but mainly laws. And I'll update you on some things that aren't brand new, but they've been some updates on. Okay, sounds good. Let's start with stuff that has to do with rental properties. Okay, because since the last time I saw you, a lot has happened. For one thing, the eviction moratoriums, the federal and state eviction moratoriums are over. I'm in Los Angeles right now. LA County and LA City extended their eviction moratoriums. And I don't really keep up anymore. It's impossible to me to keep up with what's going on where you are. So I don't know if in San Jose or anything like that, you have any separate eviction rules. I'm going to assume not.
Nope, nothing's different.
Yeah. So in other words, you're just like us, right? You're just like the state. Okay, good. So let me first, I'll talk about rentals, then I'll talk about some other new laws. It's kind of complicated with the eviction moratorium being over. Some people think, oh, great, we're back to where we were pre-COVID when it comes to rentals, right? And the answer is not quite. Almost, but not quite. For the next 6 months, we have a slightly different set of rules. But let me start with the good news. The good news is the eviction moratorium, when that ended the just cause rules regarding single family homes and duplexes and buildings newer than 15 years old. Let me back up a second. Remember, if you can think back before COVID, a couple of years ago, we had this California rent control law, and that's still in effect. And that says if the property is under California rent control, in order to evict someone, you need just cause. What is just cause? Well, obviously, if someone does something wrong, doesn't pay the rent, criminal activity, nuisance, subtenants they shouldn't have, pets they shouldn't have, they don't allow you to show the property. All of those are reasons to evict. But what if you don't have what if the tenant didn't do anything bad? You just want to evict them because you want to evict them. Under the California rent control law, you need a reason, right? And the only legitimate reasons are basically the owner wants to move in, substantial remodel, government order, or you want to take the house off the rental market. But the California rent control law that I just said doesn't apply to single family homes, duplexes, or buildings newer than 15 years old. Except under the eviction moratorium, it did apply to those. So up until a couple of weeks ago, you couldn't evict someone from a single family home unless you had one of those reasons, or if you had a house in escrow, then you could evict them. Well, now, fortunately, with the end of the eviction moratorium, we're back to where we were pre-eviction moratorium. If it's a single family home or an owner-occupied duplex or a newer property, you do not need just cause to evict the tenant. You can just evict them for any reason you want. You just don't like them, you want a new tenant, you want to sell the house, you want to fix it, doesn't matter. You don't need a reason to evict someone from a single family house right now. I'm assuming, of course, they're not on a lease. I mean, you got to wait till the end of the lease, but at the end of the lease, you can just tell them to leave. And if they're month to month, you can give them the 60-day notice. The good old NTT, notice of termination of tenancy, 60-day notice is back, and you can just do that. Okay, so that's good news. What about the other part of the eviction moratorium? The more important part of the eviction moratorium, of course, was the rule that said if someone's not paying rent, but the reason they're not paying rent is COVID related, you could not evict them. And that's been true for like more than a year and a half, right? You cannot evict them if they have a COVID reason. Well, that ended October 1st. Starting October 1st, if the tenant doesn't pay the rent, you can evict. And it doesn't matter if they have a COVID reason or not, you can evict. But here's what hasn't really back to normal yet. First of all, let's say here you are in October and the tenant didn't pay rent in September or August or whatever. They didn't pay their rent last year and you want to evict them. Well, you can evict them, but if you want to evict them for not paying the rent last year, you have to send them you still got to use the 15-day special pay rent or quit notice. On zip form, it's the PRQ TP3. And that's been around for a long time, right? So in other words, even though the eviction moratorium is over, if you want to evict someone for not paying rent before October 1st, you still got to use that form. Remember, if they had a COVID reason for not paying the rent prior to October 1st, you can't evict them anyway, as long as they paid 25%. What if I have a tenant who hasn't been paying me up until now, but they were paying the 25%? And now starting October 1st, all of a sudden they pay 100%. Can I evict them for not paying me the rent before October 1st? No. But what if they were a tenant prior to October 1st and they weren't even paying the 25%? They weren't even doing that. They were paying zero. Well, I can evict them now for that prior to October 1st rent they weren't paying. But I got to start the process still with this 15-day notice. Jody, the official name for this is PRQ TP3. So I wouldn't call it version 3. I'd just call it PRQ TP3. That's right. Okay. That's the form we still got to use for if you're evicting someone for non-payment of rent prior to this year. And remember, if they've been paying 25% under COVID, you can't even evict them. What if they weren't paying rent prior to this year and they didn't have a COVID reason? Well, you still got to send them the 15-day notice, right? And then obviously, unless they're going to lie, they're not going to return the declaration of COVID financial distress. So you can just go ahead and evict them. What about the tenant? I'm not even going to worry about last year. They didn't pay me rent October 1st. They owe me rent after October 1st. They didn't pay. Can I evict them now? Yes. Well, do I give them the old 3-day notice? Not yet. For the next 6 months, if you want to evict the tenant for non-payment of rent, it's a special form for the next 6 months. It's a 3-day notice. It's a 3-day pay rent or quit, PRQ, but it's the PRQ CRP. So right now there are 2 different eviction forms out there. The one I just talked about a second ago, if you're trying to evict someone for non-payment of rent prior to October 1st, and then there's the one for the next 6 months, if you're trying to evict someone for non-payment of rent after October 1st. Now, after October 1st, tenants have to pay. There's no excuse. COVID or not, it doesn't matter. But you still don't use the old 3-day notice. 6 months from now, end of October, that's when you're going to go back to the old, original, simple, plain 3-day pay rent or quit. Okay? But that's not for 6 months. For the next 6 months, we got this special form. Now, why do we have this special form for the next 6 months? Because this special 3-day notice form is going to tell the tenant, the landlord can't evict you unless they've applied for rental assistance, right? So I'm a landlord and I want to evict a tenant for non-payment. I can do it. But first I have to try to see if the government has any money to give me to compensate me for that. Even for rent after October 1st, if there's money there that I'm eligible for, I have to try to get it. So in other words, the purpose of this special 3-day notice form is to basically educate the tenant about that. You give them the 3-day notice and they don't pay. Okay, I'm going to file an unlawful detainer. But in the unlawful detainer process, you're going to have to prove that you applied for rental assistance and either got rejected or the tenant didn't participate for 20 days. Because remember, to get the rental assistance, you need the tenant's participation. So maybe if you haven't already applied for rental assistance, you should apply for the rental assistance before you even think about giving them a 3-day notice. Find out if you get the money, find out if the tenant doesn't respond. At that point, you can proceed with the, in other words, within 20 days, if you haven't got a response from the city or the state, or the tenant hasn't responded either with their portion, then you can proceed with the unlawful detainer. Hopefully you've already done this. Hopefully you've already applied for rental assistance and you either got it or you didn't. If you've already did that like a couple months ago, then you're good. You still got to use this special 3-day pay, rent, or quit, but 3 days after that, you can just do the, if they don't pay, you can do the unlawful detainer. So you see, it's still complicated as far as evicting tenants for non-payment of rent. It's just not normal yet. You have to apply for rental assistance. Remember how you apply for rental assistance? The website, housingiskey.com. Go there, look up your county, your city. It'll tell you how to apply. The money is still there. There's plenty of money still there. All tenants are eligible unless the tenant is making more than 80% of the median county income for a household of their size. Okay? But you have to go through the process of applying anyway. Okay, you have to go through that process in order to do that. Okay, so that's evictions.
Just real quick, Gov, is that just for residential or does that also cover commercial?
Yeah, this is just residential. Unless you're like LA, which has commercial protections as well. Under the state law, commercial is totally normal, like you've always done. You don't need to apply for rental assistance or anything like that. There's some local places like LA where it's different. Yeah, we're talking about condos or townhouses. We're talking about anything. If it's a residential rental property, this is the process. Next question is, okay, I understand the rules on eviction, but what about the tenant all these months hasn't been paying me the rent? In other words, they've been paying me the 25% minimum, but they haven't been paying me the 75%. Well, you cannot evict them for that, but starting November 1st, you can sue them for the back rent, the 75% that they haven't been paying you. But in order to file that lawsuit, you're going to have to first sign an affidavit swearing that you applied for rental assistance. So in other words, it's just like evicting or suing for back rent. Either way, you have to apply for rental assistance first. Once you apply for rental assistance, if you get the rental assistance, if the government gives you the money that the tenant owes you, well, you can't sue the tenant. You can't double dip. You can't get it twice. Let's say the government denies you the assistance because the tenant's making too much money or you don't get it all, then you can sue for what's left, right? You can definitely do that. But this starts November 1st. You can't sue till then. And then you can actually sue in small claims court for all the back rent. Remember, small claims usually has a limitation of $10,000. Not November 1st. Not for a period of time. We don't know how long it's going to last. After November 1st, you can sue for the full amount. Okay? So that's the basic concept regarding the rental situation right now. The good news is you can evict single-family home tenants for no reason at all. The bad news is it's still slightly complicated on what form you use to start an eviction. And you definitely have to apply for rental assistance before you can either evict or sue for the back rent. Okay? 6 months from now, hopefully, we will be back to completely normal, the traditional 3-day notice form, and you won't have to apply for rental assistance. One more twist on that. Let's say there's a tenant right now, and they have a COVID situation. Well, that doesn't give them an excuse not to pay the rent. But if the tenant wants to, the tenant can apply separately for rental assistance. And in other words, the tenant, let's say they're not behind in their rent, but here they are, they get COVID tomorrow. And they get health issues and they have to take care of a sick person, something like that. So this is after October 1st, tenant has a COVID issue. That no longer gives them an excuse not to pay the rent. But the tenant, if they want to, can also apply directly for the rental assistance. Even though, and if, as long as the money's there, they can get it. If they get it, great, they get the money, they can give it to the landlord and it's all good. I mean, the landlord doesn't have, I'm assuming the landlord's not trying to evict the tenant. But the tenant's thinking, well, I don't want to get evicted, but I also want to apply for the rental assistance because I'm sick now. I have a COVID issue now. And even though having COVID is no longer an excuse to not pay the rent, you can get evicted, you can still apply for rental assistance until the money runs out. When it's going to run out, it's going to run out. Okay. All right. Now that one other thing I want to talk about with rentals right now, because we're getting a lot of questions on it, is the issue of raising rent. People keep calling the legal hotline and say, can I raise the rent now? The answer is, of course you can. You could have raised it during the eviction moratorium unless you were in a city like Los Angeles that has a rent freeze. But if you don't have a local rent freeze, you can raise the tenant's rent. Okay, how much can I raise the tenant's rent? And that depends as if your property is under California rent control or not. If your property is under California rent control, it's not a single family, it's not an owner-occupied duplex, it's older than 15 years old. In that case, in order to evict the tenant, in order to raise the rent, you have a cap. In a 12-month period, you can only raise the rent by 5% plus inflation. So now you're going to tell me what's the inflation rate. And I'll tell you what the inflation rate is. If you're in San Francisco, Alameda, Contra Costa, Marin, or San Mateo County, it's 3.8%. If you're in Santa Clara County or anywhere else in Northern California, it's 4.0%. So how much can I increase someone's rent if the property is under California rent control? In Santa Clara County, it's 5 plus 4, 9%. If you were in Contra Costa County, it would be 8.8. See what I'm saying? Okay. But let's say I got a tenant in a single family house or a newer building. So it's not under California rent control. Now, of course, if you're under like San Jose rent control or something like that, you're also limited. But let's assume you're in a single family home. It's not covered by any rent control law. How much can I raise the rent right now? Can I just raise it 50%, 100%? Normally, yes, but not right now. You know why? Because there's a law in California that says if your property is in an area that's under a state of emergency, the anti-rent gouging laws take effect. You can only increase the rent by 10%. Okay. Is Santa Clara County under some type of emergency declaration? Guess what? The entire state of California is still currently under a COVID state of emergency. So nowhere in California can any landlord in residential increase the rent by more than 10%. The state of emergency is going to end at some point. course, there are a lot of other states of emergency. There's fire-related states of emergency throughout the state. I don't know if you have one in Santa Clara County or not. As long as that kicks in, you're restricted to the 10%. But right now, it doesn't matter where you are, the entire state is still under a COVID state of emergency. It's not gonna last indefinitely, but it's still there. All right. So that's the latest on raising rent. Now let's talk about other new laws.
Do you
Okay?
want to answer some of the questions that
Yeah.
are in here?
That's probably a good idea. Let me do it.
okay.
I'll do that.
All right. The very first one in Q&A is for something else, so we can wait on that.
No, I'll look at it.
Okay.
Linda's asking about the coming soon sign. That's not a question for me. That's a question for your MLS. What are the local rules that you have there? Okay. Ryan and Kelly, let's say a tenant was on a lease, but the tenant decided to move out before the lease is over. I'm assuming what you're asking me is when they moved out, they owed money. You can definitely sue them you can sue them starting November 1st for the back rent. Okay. You can definitely sue them in small claims court. Ivy, tenants moved out due to homeless, live on the San Jose parking lot, blah, blah, blah. Tenants can apply for the rental assistance even if they no longer live on the property, if that's what you're asking. Okay. All right. I think there were maybe some chat too, or is that?
There's one in the chat box.
Okay. All right. Thank you, Jody, for putting the stuff in there. Sandra, tenant has been paying their rent on time, got rental assistance for the last 3 months. Now they're paying on time again. So there's no back rent they owe. Can the landlord, I'm assuming this is a single family home. Yeah, the landlord doesn't even need a reason anymore, right? Remember, it's the first thing I said. If we're talking about single family homes, you can evict whether they're paying all the rent, and you don't even have to be selling the house. You can just give them the old fashioned NTT, notice to terminate tenancy, 60-day notice. Boom. It doesn't even matter. The landlord is trying to sell the house. That's all gone. You don't need a reason to evict someone from a single family house. That's the best news for realtors. Okay. All right. Let's move on. Let's talk about other new things. Before I talk about the brand new laws that the governor just signed last week, let me talk about one thing that's not brand new, but there's been a new development and it's kind of complicated anyway. And that's the fire hardening defensible space. There's been a lot of confusion out there. Let me try to clarify it. First of all, the basic rule is I get a listing. I have to figure out if the property, what type of fire zone the property's in. There's 4 possibilities. My house is not in a fire zone. My listing's in a moderate fire zone. My listing is in a high or a very high. If you're not in a fire zone, you're in a moderate fire zone, you don't have to worry about it. If you're in a high or very high fire hazard zone, the listing agent must provide this new form, the FHDS, fire hardening defensible space. So every time you take a listing now, you have to ask yourself, am I in a high or very high fire zone? Well, how do I know that? You go look at your NHD report. The NHD report has 2 fire boxes on it. One says very high fire zone, one says wildland fire area. If neither box is checked, you're not in a fire zone, you don't need the form. If the very high fire box is checked, obviously you're in a very high zone, you need the form. What if that box isn't checked, but the wildland fire box is checked? What is that telling you? That's telling you the property is in either a moderate or a high zone. It doesn't tell you which one. Well, Gov, you just told me I only need the form if I'm in a high zone. So I want to find out if I'm in a high versus a moderate. How do I do that? You push the NHD provider and you say, please tell me, I noticed that you checked the box on the wildland fire area. That means I'm in a high or a moderate. Please tell me which one. And they can do that for you. I mean, you can look at the CAL FIRE maps yourself, but I would go to the NHD company. I mean, you're paying them for a service. They'll do it for you. They'll tell you. Okay, so now I find out I'm in a high or very high zone. So I pull out the form. The second question I got to ask myself as a listing agent, is this house built before 2010 or after 2010? If it was built before 2010, the seller has to answer the questions where they have to check the relevant boxes in paragraph 3 on the form. Okay. What if, they have to check the box, I have a wood roof, I have single pane windows, whatever. What if the house is built after 2010? Well, you don't need to worry about those boxes in paragraph 3 of the form, but the form is still required because the defensible space part of the form is required. And that's paragraph 4 of the form. So in other words, anytime you have a listing in a high or very high fire zone, the form is required, and you do have to fill out paragraph 4. By the way, I'm assuming this is a TDS transaction. If it's a probate sale, REO sale, bankruptcy sale, brand new house with a public report, or a sale by a trust where the trustee has never owned the property, you're exempt from a TDS. If you're exempt from a TDS, you're exempt from this form as well. So this form is only required, you're listing 1 to 4 property in a TDS transaction, and it's in a high or very high fire zone. By the way, this form, for years people have asked me, what are the disclosures I really have to do when I take a listing? And you know what I like to say they're big disclosures and they're little disclosures. What's the difference between a big disclosure and a little disclosure? A big disclosure, when you give it to the buyer, they have a 5-day right to cancel. A little disclosure, you give it to them, but they don't have the right to cancel. What are the big disclosures? Up until this year, there were 4 of them. You're familiar with them: the NHD report, the TDS, transfer disclosure statement, the seller property questionnaire, SPQ, and the lead paint form if the house was built prior to 78. You give those 4 forms to the buyer's agent, the buyer has 5 days to walk. What a lot of you do in the Bay Area, I know, is you make sure these disclosures are part of a package and you make them available to the buyer before they even sign the offer. If the buyer signs these big 4 disclosures prior to signing their offer, they don't have a 5-day right of rescission. Well, this new form, the FHDS, this is the 5th big disclosure. This form does trigger a 5-day right of rescission on the part of the buyer, unless you get the buyer to sign it prior to signing the offer. So now we have 5 big disclosures. By the way, what are the little disclosures? The FERPTA form, the QS, the environmental hazards booklet, the earthquake booklet, the HOA, homeowners association disclosure documents. Those are all required, but they don't give the buyer a 5-day right to cancel. Okay. The big 4, now the big 5, give the buyer a 5-day right to cancel. Okay. All right. Let's get back to this FHDS. I'm a listing agent. I've determined I'm in a high or very high fire zone, so I'm getting out this form. I determine whether the house was built before or after January 1st, 2010, which determines whether the seller has to check the boxes in paragraph 3. But regardless of when the house was built, the listing agent, the seller, we have to fill out paragraph 4B on this form. We got 4 choices: 4B 1, 2, 3, or 4. 4B2, 3, and 4, they have check boxes. If you don't check any of the boxes, you default to 4B1. And 4B1 is the one you're usually going to have. Most of your deals are going to be 4B1. How do I figure out which box to check on this form? Well, you have to figure out, is there a local law in San Jose, Santa Clara, wherever, whatever city I'm in, or is there a local law in Santa Clara County that requires the seller or the buyer to do a defensible space inspection at point of sale? Guess what? I can answer that for you. We've researched this, and unless there's a fire district that you're running into that we're not aware of, nowhere in Santa Clara County is there a local law that requires the seller to do a defensible space inspection prior to close, or requires the buyer to do something. So that being the case, you're definitely not going to check paragraph 4B3 or 4. I've done your research for you. So now it comes down to, do I check 4B2 or do I not check anything? Well, 4B2 is, you check that box. You have to ask the seller a question. Hey, seller, in the last 6 months, has any fire company come out to your property to do a defensible space inspection? There are some places like Big Bear down here, and there are other places around Southern California. The fire company automatically comes out every 6 months or so. They just do that. So if you're in one of those areas, you're going to ask the seller, hey, has the fire company been out here in the last 6 months to make sure you have your 100 feet of defensible space? And they're going to say, yeah, they were here, as a matter of fact. You're going to say, great. We're going to check the box on 4B2, and we're going to give the paperwork that the fire company gave you to the buyer, and we're done. Mostly though, usually though, when you ask the seller that question, they're going to say, nope, I have not had a defensible space inspection on this property in the last 6 months. If that's the case, you're not going to check any of the boxes in paragraph 4B. It's going to default to 4B1. And what that says is the buyer is agreeing that within a year after close, the buyer is going to reach out to either CAL FIRE or the local fire company to have them come out and check out the property and get them to make sure that they can get documentation that they're in compliance with the 100-foot defensible space rules. By the way, if you currently live in a high or very high fire zone, you're supposed to have 100 foot of defensible space already. And if you don't, CAL FIRE or the local fire company can come out to your property anytime they want, before this law ever happened, to check to make sure you have it. And they can penalize you if you don't. That's nothing new. The only really new thing here now is if there's a local ordinance in place requiring you to do something, you have to do it and disclose that to the buyer. If the seller has randomly had a defensible space inspection in the last 6 months, they got to disclose that to the buyer and give them the paperwork. And if none of that happened, which will be 99% of your sales, the buyer now has to is agreeing that they have to reach out proactively during the next year to a government fire company to see if they're in compliance. So once you tell the buyer this, they're going to say, okay, do I call CAL FIRE or do I call the local fire company? And the answer is, well, if you're in a state fire responsibility area, you're going to call CAL FIRE. If I'm in a local, I'm going to call the local fire company. And the next question is, they're going to ask you is, well, how do I know if I'm in a state or a local fire responsibility area? You could look at the CAL FIRE maps. We have a Q&A on this, by the way, a Q&A on this on this whole issue of AB 38, the defensible space and fire hardening. And there's a link in the Q&A, or just Google Cal Fire, you can look at their maps. But you know what I would do? I would just call up the local, I look up Cal Fire in the phone book, call up the local office and say, I want to schedule an inspection regarding defensible space. And if you're in a state area, Cal Fire will say, sure, let's do it. And if you're not, Cal Fire is going to say, sorry, your property is not in our jurisdiction. Call your local fire company. So then the buyer will call the local fire company. You know what we've been finding out? A lot of local fire companies, when you call them up, they're going to say, you want us to come out and do an inspection? No, we don't have time for that. We're too busy. We don't do that. And they don't have to. If they don't want to do it, they don't have to. Then the buyer is going to take note. I called Joe Smith at the local fire company. He said they're not doing inspections. I'm done. And by the way, the buyer is going to do all of this after close. It's not the realtor's job. So to summarize, the listing agent's job is, number one, figure out if you're in a high or very high. Number two, figure out if the property was built before or after January 1st, 2010, which will determine whether or not the seller has to check the boxes in paragraph 3. Number 3, you're going to determine if there's is there a local law requiring the seller or buyer to do anything? And I did that for you. I told you no. And the 4th thing you're going to do is ask the seller, have you had a defensible space inspection for some reason during the last 6 months? Buyer's agents, what's your job? Well, once the listing agent gives you this form, you're going to look at it. And if you see none of the boxes are checked in paragraph 4B, so it defaults to paragraph 4B1, you're going to just point out to your buyer, do you see what you just agreed to, buyer? Within the next year, you got to do something. You know what some buyers are going to say? What if I don't? What if I don't call anybody in the next year? Is there a penalty? And the answer is, we have no idea. Is Cal Fire and the local fire company going to keep a record of every house that sells in a high or very high district and go back and start checking on them? I doubt it. You never know. So before I go on to the new thing that happened in this law, is what's causing problems out there is Cal Fire, up until recently, was putting out information saying this law requires every seller to do a defensible space inspection before they sell their house. That is false. We sort of convinced them of that, although they still have stuff on their website that makes it that says something like seller has to do an inspection or the buyer can do it within a year after. Well, I'll tell you right now, the seller never has to do it unless you're in a local community requiring that, like Truckee, for example. But nowhere where you are does that. We've also come across, I don't know about where you are, but down here, we occasionally come across local fire districts who they also think that this law requires a seller, when they get a listing, to do a defensible space inspection before they can close. That's not true unless that local jurisdiction has a law on the books already saying that. This new law doesn't say that. So we're trying to educate those too. We're working with local fire companies out here. Make sure we're having some progress. It's still a little bit of confusion out there. I'm telling you this because realtors keep calling us up on the hotline and says, the fire company, the other agent told me I got to do this inspection or I can't sell the house. The buyer's agent will call up the listing agent and say, well, where's the required defensible space inspection you're supposed to give me? You have to give it to me. And the answer is they don't, because it's not required unless you're in a certain select cities in Placer County and a couple of Marin County, etc. Anyway, just want to throw that out there. There's one new thing. There's a new law, though, that just got signed that affects this. But it doesn't take effect for a year. And we're going to solve the problem before then. Remember I just told you that This form is required if you're in a high or very high fire zone. And you can always determine that by looking at your NHD report. It'll tell you if you're not in any zone. It'll tell you if you're in a very high. And if you're in the wildland fire box, that tells you you're in a state responsibility area and you're either in a moderate or a high. So if you're in a high, it'll tell the form will tell you that at least that's a possibility. And then you can clarify that by asking the NHD person. New law just got signed by the governor, SB 63. SB 63 now requires CAL FIRE to map high and moderate fire zones in local responsibility areas. Let me back up a second. Every one of us in California, we're either in a state fire responsibility area or a local. If we're in a state responsibility area, CAL FIRE has mapped it either very high, high, moderate, or nothing. But right now, if you're in a local responsibility area, you're either in a very high or nothing. This new law is going to require CAL FIRE in the local responsibility areas to designate not just very high and nothing, but very high, high, and moderate. What's the problem with this? The NHD law only requires the NHD company to tell you if you're in a very high or a high or moderate in a state responsibility area. The NHD company is not required right now to tell you if you're in a high fire zone in a local responsibility area. There's no checkbox for that in the form. But come next July, when this law takes effect, the FHDS form that I've been talking about will be required if you're in a high fire zone in a local area. But there'll be no way to find that out by looking at the NHD report. So we're probably going to have to try to get the NHD law changed so the NHD report by next July will tell you what you need to know. All right, enough on this stuff. Let's talk about brand new laws the governor has just signed. I've got good news for you. There's not many new laws that are really going to change your life. Usually you don't want to hear about new laws. I got to do something new I didn't have to do before. I got good news for you. Most of the new laws aren't going to change your life at all. But they're worth talking about. They're related to real estate. I think the most important new law that you're probably interested in is SB 9 and SB 10. SB 9 is a new law that says if I'm zoned R1 single family home zoning and I have a single family house there, I can now pretty easily turn my single family house into two houses, into a duplex. It doesn't have to be an attached duplex, it can be two separate properties. Because the SB 9 says effective January 1st, if you want to convert one into two on your lot, all you need is ministerial approval. No environmental impact report, no hearings. As long as you meet objective design and health and safety and building standards, so the community can have objective standards regarding design and building and safety. As long as you meet those standards, they have to approve it. They have no discretion not to approve it if you meet their objective, reasonable standards. So it's going to be pretty easy to convert one house into two. But not only that, Gloria, you're right. In addition to what I just said, you can do a lot split. And then you have two lots where you used to have one, and on each one, you can do a duplex. So you can turn one house into four on the same lot. There are restrictions on this, though. Not just anybody can do this. Number one, when we talk about the duplex thing, or any of this only applies in urban areas, urbanized areas or urban clusters. How do I know if I'm in one of those? Those are defined by the US Census. You can look it up. Most of you guys, a lot of you guys, I think, are in urban areas. Can't do it on farmland, wetlands, properties identified for conservation, habitats for certain species, historic areas, landmark areas, or hazardous waste sites. So that's one restriction. Another restriction is you can't do this on a property where it's been tenant occupied at any time in the last 3 years. You can't do this on a property that has any rent control units, even if they haven't been occupied in the last 3 years. And the city or the county still has an overall general right to make a determination is, well, this development that this property owner wants to do is going to have a material specific adverse impact on health or safety or the physical environment. Assuming you meet all that, though, you'll be able to turn your house into 2. What about the lot split? Well, to do the lot split, so you can potentially turn one house into 4, there are a couple of other restrictions. In addition to what I just said, urban area, no rent control there, no tenant there in the last 3 years, you meet objective standard. In addition to that, to do the lot split, first of all, the lot has to be 2,400 square foot or more. Let's say the lot you are trying to split was itself created by a previous lot split, you can't do it. So you can only do it sort of once. And if the owner of the property has previously done a lot split on an adjacent property, they can't do it on this property. This is trying to make it so it's not like developers or speculators doing this. And here's the most important part. Anyone who wants to do this lot split has to sign an affidavit committing that they will live as their primary residence in one of the units for the next 3 years, 3 years from the date of the approval of the lot split. In other words, the idea is that the only people that are going to be doing about this are people that are invested in the community, because they're still going to live there, right? And they can't do it on next door, then one after that. They can just do it on this one place. They've got to live there for at least 3 years. Now, what about what I told you before? Okay, so you can turn one house into 4, potentially, right? Which sounds like a big deal. But did you know even before this law in California right now, it's pretty easy to convert one property into 3? Because you may remember me telling you this last year and the year before. The rules regarding accessory dwelling units and getting approval for those have been very much streamlined. So it's pretty easy now to get an approval to build a granny flat in the backyard. As long as it's 4-foot setback, no more than 16 feet high, you can pretty much do it with the same type of automatic ministerial approval that I just talked about. Plus, in addition to that, it's pretty easy to get basically convert your garage or convert the back room into also an accessory dwelling unit. So it's not that difficult right now to convert 1 into 3. So this new law is going to enable you to go 1 into 4. But now you're going to say, hold on a second. Does this mean I can take the one house, do a lot split, put a duplex on each one, so that's 4 units, and then can we do accessory dwelling units in addition to that? And the answer is no. The law is very clear. if you create units under this process under SB 9, you cannot do, you cannot also do in the future, build an accessory dwelling unit or convert space into an accessory dwelling unit. So it's really maximum going to be 1 to 4. Okay. A couple other things. Under this process, if you're going to get permission to go from 1 to the duplex or the lot split, whatever, on the resulting units, there can be no short-term rentals of less than 30 days. No Airbnbs permitted at all. Okay. What about parking? Can the local community require that you provide for extra parking if you do this lot split or create this new unit? The answer is they can require you to add 1 parking spot per new unit unless the property is within a half-mile walking distance from what's called a high-quality transit corridor or a major transit stop. What if the property is within a half-a-mile walking distance from that? Then they can't require any additional parking being created for this purpose. Okay. Can they require a setback? 4-foot setback? Yes. But if there's a property already there that doesn't have a setback requirement, and you're going to leave it there or rebuild on the same place, they can't require this setback requirement. Okay.
Couple questions on SB 9.
Yeah, I'm going to get to those in a sec.
Okay.
I just want to make sure, before I get to the questions, a couple more things to answer is, what if I'm on the coast? Does this supersede the Coastal Commission and the California Coastal Act? The answer is no. Coastal Commission takes precedence over this. Second, and here's the big question that hasn't been answered yet. Does this supersede local CC&Rs, private covenants and conditions? The answer is probably, but it hasn't been resolved yet. And that is going to require the legislature to clarify this or some court case. In other words, if you're in an area, you've already got CC&Rs that prevent you from doing this, can you do it anyway? And the answer is not clear yet. Okay. All right. First, I'll look at Q&A. Don says SB 9 does not apply to properties in a very high fire hazard areas unless mitigated. I'm not so sure what that means either. What I think it means is if you're in a very high fire area, you know, right now, if you're in a very high fire area, if you build something new there, it's got to conform with certain fire building standards. But if you're already there, built before 2010 under the old building code, not necessarily. I think what this might mean is if you're going to try to, I mean, I think it's pretty obvious. If you're going to build something new, and this definitely involves building something new, you're in a very high fire zone, it's got to meet the building code, those mitigating factors. Or what if I'm just going to take my existing house and sort of transform it into a duplex? Well, then you're probably going to, even though it's not new construction completely, you're probably going to have to bring it up to the current building safety codes. Okay. Sandra, the setback requirement is the city or county can require a 4-foot setback for these new units, unless you're just converting a unit that's already there that doesn't have a setback requirement, if that makes any sense. Let me go to the chat. I know Jody's been helping me out here. Yep, Jody's been answering. Richard, is there any difference, easing of application process, reduction of costs for subdivisions in general? And yes, there's a couple laws out there which I'm not talking about today. I'm not really up on the details, but you're right. There are some other new laws just trying to make the entire process more streamlined and quicker. But I'm talking about a specific law that is talking about a specific sort of increasing the number of units, okay? So that's SB 9. What about SB 10? So SB 9 that I just talked about is basically saying the state is overruling the cities. The state is telling the cities and counties, you have to allow this. SB 10 is not the state requiring the locals to do anything. SB 10 is the state giving the locals permission to do something. What is it that the locals have permission to do? The local cities and counties now will have permission, if they want to create a streamlined zoning process, ministerial approval, like I just talked about, no environmental impact report, no hearings, to, on certain properties, build up to a 10-unit apartment building. Now, these are only in what are called transit-rich areas. What is a transit-rich area? That's where the parcel is within a half a mile of a major transit stop, like a bus station, train station, ferry station, or it's within a half a mile of a intersection where at least two major bus routes stop at least every 15 minutes. That's called a transit-rich area. Or if you're in a designated urban infill area. If you're in one of those areas, if the city wants to, they can provide that developers in those areas can build up to a 10-unit apartment building with the accelerated streamlined process, no environmental impact report, no CEQA. But they definitely also cannot do this in a high fire zone, historic district, or if it requires demolition of a rent control unit, or if there's an HOA there. So remember how I said SB 9? It's not clear whether the HOA supersedes this. SB 10, it is clear. If you've already got an HOA in there regulating this property, you can't necessarily do this. So this is not a state mandate. This is a state empowering locals to do something. Okay. So those are the two big laws regarding that have caused a bit of controversy regarding people say, oh, single family zoning is gone. To me, it's already been gone with the fact that you can build accessory dwelling units pretty easily. But you're right, an ADU is not the same thing as a whole nother unit sometimes. By the way, if you're doing a lot split, I didn't mention this, the lot split has to basically be two equal lots. Or to be specific, neither one can be more than 60% the size of the original. And remember, it's got to be at least 2,400 square foot lot. Okay. All right. We can come back to this, but let's talk about other stuff. Let's talk about other new laws that the governor has signed. There's one that affects you directly. How do you like that? And it's called AB 830. And this is what some realtors have been pushing for a while. So we made sure we got it. We made it happen. Let's say you get your real estate license and you have a particular last name. And then for some reason you change your last name. Maybe you get divorced. Maybe you get married. Maybe you just change your last name. So you renew your license in your new last name because you changed it. There's a new law that says effective January 1st, when you're marketing yourself on your signs and all your advertisement, you can use either one. You can use your previous last name that you previously had on your license, and you can use your last name on your current license. You can use either one for marketing purposes, as long as the DRE is aware of both of them. And of course, they're going to be aware of them because you had it on your previous license. Okay. All right. There's a series of new laws regarding what I would call fair housing. There's a big push for fair housing right now, no more discrimination, and there's a new laws in this area that affect this in certain ways. For one, there's one that affects you directly, SB 263, requires all real estate licensees, in order to get your real estate license, you're going to have to take a 2-hour class. By the way, this isn't effective till January 1st, 2023. You're going to have to take a 2-hour class on bias, on implicit bias. And then on your first license renewal, you're going to have to take another 2-hour class on implicit bias. And on all subsequent license renewals, you're going to have to take a 1-hour class. What is implicit bias? Well, first of all, I understand the general concept. When I'm selling real estate or providing brokerage services or leasing real estate, you can't discriminate. You can't discriminate against someone based on their race, religion, color of skin, country of birth, age, gender, disability, sexual orientation, marital status, family status, gender identity, etc. There's 22 categories in California. And you know where to find those categories, because there's this form called the Fair Housing Advisory that is attached to your listing forms, and it's attached to your purchase contracts explaining all this. Okay. Bias means you can't favor one buyer over another, or one tenant over another, or one client over another based on the fact that they have, based on the fact that they're in one of these categories. That's bias. If you are, you're biased. And obviously we all know that's against the law. But there's also just like implicit bias. Bias that people aren't even necessarily aware of. We all have biases. People tend to favor people who are like yourself. And sometimes they don't even recognize it. So there's classes you can take on this that sort of help you sort of first of all, these classes are going to educate people on the rules, the fair housing rules, and it's going to talk about how to identify bias and how to address it if it's there. So, part of this thing is this whole thing with the buyer love letters, I mean, the idea is these letters are not illegal. In the state of Oregon, they're illegal, but they're not illegal. But the idea is buyer writes an offer and they also write a personal letter to the seller. Sometimes the letter says things like, your house is so beautiful, you've taken such good care of it, I promise I'll take care of it too, blah, blah, blah. Nothing wrong with that. But sometimes these letters say things like, yes, my husband and I and our 3 children, one of whom is disabled, just emigrated here from Canada, and I'm a dentist and my husband's a teacher, and blah, 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 blah. So you're telling the seller all of these personal things about themselves. As a seller, I don't want to know that, because if I don't know that, no one can ever accuse me of being biased in favor of someone or against someone. But I mean, this letter I just described, they disclose their marital status, their family status, what they do for a living, where they're from, disability, etc. If I don't know that stuff as a seller, I can't very well be accused of being biased against these people or in favor of these people. And we're all just sort of unconsciously biased sometimes. We don't even know it, but we're favoring certain types of people over other types of people. So anyway, there's a new training requirement there. Okay, that's not going to kick in till a year from now. All right. Another law that will affect you is, I hate to tell you, but there's going to be another form, AB 948. There's a new form it's called the Appraisal Discrimination Notice. I don't know if you've been following this in the paper sometime on the media, but there have been some testers, they go out and they get appraisals on the same exact property. The appraised value from the appraiser comes in differently depending on who the people are who ask for the appraisal. In other words, people of certain racial groups, the property tends to get appraised less than others. You know, I mean, just clearly biased appraisals. So what does the new law say? For one thing, it says that appraisers also have to take this bias training. But it also says that when you're selling a house, you must provide a form to the buyer and the seller advising them, hey, appraisals are supposed to be not biased. They cannot be influenced by certain categories like we just talked about. And this notice is also going to disclose on the notice how you can file a complaint if you think you had a biased appraisal. So this is a requirement that you give this information to the buyer and the seller. So this is going to be an attachment to the purchase agreement. Right now, if you notice, there are 6 attachments to the purchase contract: the 2 agency forms, the wire fraud advisory, the buyer inspection advisory, the fair housing advisory, and the California privacy notice. By the way, are any of those required by law? Just the privacy notice. And technically the agency disclosure form is also required too. This new form, which is going to be the 7th attachment to the purchase contract when it finally comes out, probably next July, is also a required form. But you're not even gonna have to think about it. It's not something you fill it out. It's just going to be attached to the purchase contract. By making it part of the purchase contract, you've taken care of your obligation. So that's a new thing coming. Okay, and it's probably not going to come out till July of next year. All right. Other new laws regarding discrimination. You know that you know what's called a restrictive covenant. Sometimes you got a piece of property, and attached to the deed is a covenant that says something like, this property can only be used as a Catholic church or something like that. That's legal, by the way. You can limit in certain ways, even though that's favoring one religion, certain types of restrictive covenants. This property can only be used as a daycare center, whatever. You come across those every now and then. The person who sold the property sold it under the condition that it's perfect. You know, there's some restrictions on who you can sell it to. In your area may say something like, this property can never be sold to a Dodger fan or something like that, right? That's perfectly legal. That's not a protected class, Dodger fans. But of course, there's some that are flat out wrong. They say things like, this property can only be sold to a Caucasian. Now, if you saw that, you know that's simply not enforceable. Those things haven't been enforceable since 1948, but they still show up. And some people are very offended when they buy a house and they see on the deed there's a restrictive covenant. Even though they know it's not enforceable, they don't even want it to be there. So there's a new law, AB 1466, that's simply going to make it easier to remove those. First thing is, right now, let's say I own a house and there's a restrictive covenant on, I want to get it removed. I actually have to pay a fee. I got to go to the county recorder's office, and they got to get approval from the county council to determine whether it really is unlawful. And this can take a long time, cost money. It's not very streamlined. This new law says, if you want to do this, there's no fee, and the county council has to give you an answer within 3 months. And not only that, up until now, the only person that can apply for this modification is the actual owner of the property. Starting next year, anybody can do this, not even the property owner. I guess a realtor could do it on behalf of your client if you felt like it. You could actually go to the county recorder's office and go through the process of getting this unlawful restrictive covenant removed from the deed. Second thing this law says is if you, the realtor or the title company or escrow company or the county recorder happens to be aware that you're selling a house that does have a unlawful restrictive covenant, you have to tell the buyer and the seller, by the way, did you know that there's a restrictive covenant against this property? And did you know there's now a streamlined way you can get it removed? I don't think you guys as realtors generally know when you're selling a house whether or not there happens to be a restrictive covenant against it. But just in case you do know, you're supposed to disclose it. And the third thing this law says, which is probably going to solve the whole problem, is it requires all local county recording offices to set up a program by next July where the county recorder office itself is going to set up a program where they, the recorder's office, are going to go through all of the recording document, all the deeds in their jurisdiction, looking for unlawful restrictive covenants. And when they find them, they're going to remove them. So eventually the county recorders are going to take care of this problem. Of course, there's no time deadline for them to do this. I'm sure it'll take a long time. In the meantime, it's easier for the individuals to be able to do it themselves. Okay. All right. Couple more on fair housing. There's one that's kind of interesting regarding equal access to properties. Right now, did you know that there are some apartment buildings act? This is AB 491. Right now, there are properties, multi-unit properties, where some of the properties are affordable, are designated affordable units, and other units are market rate. Right? You might have heard about this. I mean, they exist right now. Some in certain areas, some properties are just designated, set aside for affordable, certain income level, etc. Did you know right now in these properties, occasionally they have them set up so there's this swimming pool for the people in the market rate units and this swimming pool for the people in the affordable units, or there's a separate entrance for the people who live in the market rate units as opposed to the other ones, et cetera, et cetera. That's going away starting by January 1st. In multi-unit buildings where they have different income levels in there. In these so-called multi-income properties, there cannot be any distinction between the market rate units and the other units as far as access to facilities. Also, they can't have all of the affordable units on one floor and the market rate units somewhere else. They can't be just segregated like that either. So that's kind of interesting. One more thing that's sort of related to fair housing I want to talk about is there's a new law regarding emotional support animals, AB 468. As you probably know, there's a lot of confusion out there and there's a lot of abuse of this whole concept. There are two different types of animals I'm talking about. There's service animals and emotional support animals, and they're treated differently. Did you know a service animal, if someone has a service animal, they have the absolute right to take that service animal into all public places, restaurants, etc. But did you know if you have an emotional support animal that's not a service animal, you don't have the right to take them into public places? The restaurant can say, no, you can't come in, no pets, no animals. No, it's not a pet, it's an emotional support animal. I don't care, they can't come in. If it was a service animal, they'd have to let them in. Did you know that service animals have to be dogs or miniature horses? But that's pretty rare. So when you think of a service animal, it's a dog. Whereas an emotional support animal could be a dog, or it could be a whole bunch of other things. So how does this apply to real estate? Before I talk about the new law, real estate, I'm a landlord. I'm an HOA. I have a no pet policy. Someone shows up with an animal and I say, I'm sorry, this is a no pet facility. And they say, no, it's not a pet. And you say, what is it? And they say it's a service animal. Well, if they say it's a service animal, it better be a dog or a miniature horse. So if it's not a dog or a miniature horse, you can say, nope, that's not a service animal. But if it is a dog or a miniature horse, you're allowed to ask them two questions. Number one, are you disabled? If they say yes, you're done with that question. You can't ask them what their disability is. You can't ask them for proof that they have a disability, but you can ask them the question. So what if they say yes? Then you're allowed to ask a second question. What task is your dog or miniature horse trained to perform? And obviously, by telling you that, they're probably going to be telling you what their disability is, but you're allowed to ask the question. But let's say they say, yep, I am disabled and my dog is trained to help me hear certain noises or whatever. You're not entitled to any proof that that dog has been trained. You have to take their word for it. Now, if they're not telling the truth about either of those things, they're committing a criminal act. But you can't demand proof. Once they say that, you got to let them in. But what if they show up not with a dog, with a cat, or with a fish, or a peacock, or a gorilla, or something? Or maybe even it's a dog. And you say, I'm sorry, no pets. And they say, no, it's an emotional support animal. Ah, it's a comfort animal. Now, believe it or not, you are entitled to proof. What are you entitled? You're entitled to proof, something in writing from someone who's been providing care to this person, saying that this person has a disability and needs an emotional support animal. Isn't it interesting? If they say it's a service animal, you're not entitled to proof. But if they say it's an emotional support animal, and if it's something other than a dog, it can only be an emotional support animal, you're entitled to proof. This is where the fraud comes in, right? There are people out there fraudulently giving this documentation to people, saying, oh, yeah, you sound like you need an emotional support. I'll give you the paperwork. So there's a new law. The new law says anyone who provides this type of paperwork has to provide a notice to the person they're giving the paperwork to, saying, number one, this is paperwork for an emotional support animal, not a service animal. This animal has not been trained to do anything. This is an emotional support animal that doesn't have the same rights as a service animal. And it also says on this notice to the person, by the way, fraudulently claiming that you need an emotional support animal when you don't, you don't have legitimate documentation, that's a criminal offense too. So up until now, it was a criminal offense to say I need a service animal dog. Now it's also a criminal offense to say fraudulently that I have authorization that I need an emotional support animal. And the person who's providing the caregiver that's providing this information, remember, they really have to have a relationship with this person. They can't be someone they just met on the internet. So is this going to change anything? I don't know. Are people still going to go out and get fraudulently obtained documentation I suspect it's still going to happen, but maybe this will stop some people when they realize, oh, this is a crime. If it's a crime to do this fraudulently, and oh, this is now I understand the distinction between a service animal and another animal, and oh, this person has to have a personal relationship. Maybe it'll deter some people from, because some people I think abuse this. They don't really need a service animal. They just have a pet, and they go to some, criminal who gives them the fraudulent paperwork, and now all of a sudden you got to rent to them. Now, Angela's asking me a good question. Who's qualified to be the caregiver? Unfortunately, in my opinion, it's not just licensed healthcare providers. It's anyone who's been taking care of this person. It could be a family member who's been actually living with this person, taking care of them. It doesn't have to be, if it's a healthcare provider, the healthcare provider has to swear that they've actually had a clinical evaluation of this person. But if it's not a healthcare provider, it could be someone else who just has a reasonable basis based on their relationship to say, yes, in my opinion, even though I'm not a doctor, in my opinion, this is a disabled person that needs an emotional support animal. That's a big loophole. You're right there. Okay. Oh, by the way, I forgot there was a question I didn't get before that had nothing to do with this. Okay, where was it? Maybe it was in the Q&A. I know someone asked me a question. Hang in there. Oh yeah, someone asked me, are there any restrictions on evicting Section 8 tenants? No. You can go back to evicting Section 8 tenants. The only restriction on evicting Section 8 tenants is first you have to terminate the Section 8 status with a 90-day notice. Then you can evict for the just like normal. Someone also asked me the fire hardening defensible space. How does that apply to a mobile home park? That's a great question, because I live in a mobile home park. I'm supposed to have 100 foot of defensible space, but I don't really control the space there. It's controlled by the park. So how can I reach out and get a defensible space inspection when I have no control over the defensible space? Same thing on a condo. Okay, I just bought a condo. I'm in a high fire zone. I have to make sure that I have 100 foot of defensible space. But I don't control that. The HOA controls that. So even though the law doesn't specifically address this, common sense says the individual property owner in a mobile home park or a homeowner association does not have to do anything, because you don't control the defensible space. But maybe the HOA or the mobile home park has an obligation to do this. This is another thing that needs to be clarified. Okay, that's a great question. Okay. Someone else I thought asked me something. Getting back to the emotional support animals. So we have the documentation from a legitimate caregiver that says this person needs an emotional support animal. Does that mean I have to take the animal? No. When it comes to emotional support animals, you only have to make a reasonable accommodation, which means you don't have to accept any old animal. If they show up with a gorilla, you can say no. They show up with a peacock, you can say no. What if it's a duck or a bird or something like that? The question is going to be, is it reasonable? Is it like an eagle or something? You know what I mean? Is it an animal likely to cause damage? Is it an animal likely to make an unusual amount of noise? Is it an animal likely to pose a risk to the neighbors? It's a 500 square foot unit and it's a 300-pound dog. Is that just ridiculous to have a dog that big? And that's, you know what I mean? The landlord has some discretion to say, okay, I get it. You're entitled to an emotional support animal, but that does not mean you're entitled to this emotional support animal. You can push back on the grounds that that's not reasonable. Okay, so that's a good question. Where if it's a service animal, if it's a trained service dog, you can't say, okay, I understand you have it entitled to a service dog, but I don't like that dog. That's not reasonable. You can't do that with a service. You don't, there's no test of reasonable accommodation. Okay. Now, what if, can the landlord just have a policy, no pit bulls? As a breed, no pit bulls. Can you say that? No, you can't. You have to basically have a reason why that particular pit bull is a problem. So you can't just say a certain breed based on, unless it's a size issue. Like I said, I've seen courts say that a size issue, you can sort of have a, yeah, you can't have a dog bigger than 200 pounds or something like that, because these units aren't big enough or something like that. You can still do that. Okay. Mary, can you please repeat in what case you can exempt TDS? I think what you're saying is, when is a TDS not required? And if a TDS is not required, an SPQ is not required, and also this new FHDS form is not required. So when can I sell a residential 1 to 4 without doing the TDS or the FHDS? The answer is probate sale, REO sale, bankruptcy sale, or sale by a trust. But if the trustee of the trust used to be on title or occupied the property within the last 12 months, that trustee is no longer exempt. Okay. Sandra, regarding Section 8. Yeah, all you got to do is you give them 90-day notice that you are terminating the Section 8, your Section 8 status. However, I should be a little bit careful, but when I say this, in other words, maybe I should have said this right up front. You can't terminate your Section 8 status. And the question is, why are you doing this? In other words, you can't terminate a Section 8 tenant just to get a different tenant who's not Section 8. But if you want to terminate the Section 8 tenant because you want to sell the house or move in yourself, absolutely give the tenant a 90-day notice telling them, I'm terminating the Section 8 because I'm no longer going to be renting this property. And then after that 90 days, then you could give them another 60-day notice. But if you just want to terminate a Section 8 tenant because you don't want a Section 8 tenant, you want a regular tenant, that you cannot do. Okay, that you can't do. So I should have made that distinction. Okay, all right. Nothing else in Q&A. Nothing else in the chat I see right now.
There was one, aren't Section 8 leases?
Not necessarily, but I mean, they still can have a termination date. No, I mean, if it's a lease, you can wait till the end of the lease. In other words, Section 8 tenant can't stay there indefinitely. You can still kick them out to sell the house or move in yourself. Just don't kick them out just because you don't want a Section 8 tenant anymore. You want a different tenant. That's not a good, that's something you probably can't do. Okay. Let's see, Q&A, blah, 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 blah. Yes. Yes, Sandra, yes, and yes. Okay. Are there any other new laws you should know about? Yes, a couple more. Those are the big ones. And as you can see, there's not a lot of stuff that's really significant, dramatic, that's really going to change your life. Maybe a couple more that, in case you have a slight interest in. You know how we got this California rent control law? that says if you're under California rent control, there's a cap on how much you can increase the rent, and also you can only evict the tenant for just cause. Does this apply to mobile home parks? So I'm renting a space in a mobile home park. Is this restriction applied? Is the mobile home park restricted? The answer is no. There are a lot of local mobile home rent control laws, but there's no state law. But what about this? I'm renting a mobile home in a mobile home park. The mobile home that I'm renting is owned by the park. Is that under the California rent control? Up until now, the answer was no. Now, because of AB 978, yeah, it is. So if you're renting a mobile home in a mobile home park owned by the park that's 15 years or older, that mobile home park, who happens to be your landlord, in other words, they're not renting you the space, they actually own the mobile home, and they're renting you, you're renting the mobile home. They are restricted by the California rent control law. Remember, the just cause rules only applies to tenants who've been there for at least 12 months. So you have an older building, you're under California rent control, so you can only evict them for certain reasons. That only applies to a tenant who has been there at least 12 months. So you could always, if you wanted to, get a new tenant, make them month to month, and evict them before the 12 months. And then you don't need a reason. Once they're there 12 months, and it's a older than 15-year building, then you're going to need just cause to evict them. You can't just evict them because you don't like them. It has to be, you know, owner move out, owner move in, or taking it off the rental market, or substantial remodel. Okay, so that's an interesting twist on that. I think that is really all of the brand new laws you should really need to know about. We have a handout, I think we're putting it up on the website today, that summarizes all the new laws. I think the most important ones, as you know, are the eviction moratorium that ended, but it transitioned into something new that I was talking about as far as evicting people. SB 9 and SB 10 are interesting and important. They don't necessarily affect your daily life. There is going to be a new appraisal discrimination form attached to the purchase contract. You can use your old last name. You can remove restrictive covenants. It's a little bit tougher to get away with emotional support documentation fraud. None of this stuff is earth-shattering, I think you'd agree. What about in the forms world? Well, it's been an interesting year for forms. Now that we're rid of all the COVID forms, there haven't been a lot of other forms this year. I've already talked about the Fair Housing Advisory that came out. There's also I already talked about the fire hardening defensible space form that came out. The only other brand new form that came out this year is called the Transfer of Listing, TOL. Let's say there's an agent changing offices and they want to take the listing with them. They don't have the right to do that without the broker's permission. But maybe the broker is saying, okay, you can take that listing to the new broker. We now have a great form to document that, to protect everybody, deals with release of liability, release of compensation, talks about agency relationship, talks about file keeping requirements. So it's a good form if you're ever in that situation. Okay. Of course, the very big news is at the end of this year, in December, there's going to be a new purchase contract. So if you haven't already done so, you might want to take a class. I'm giving a class tomorrow. We're giving classes throughout the next couple months. It's a 10-page contract changing into a 16-page contract. So you know there are going to be some changes. Actually, once you look at it, you'll see, well, it's a lot longer, but it's really not that different. Because rather than add a lot of new stuff, pretty much all the paragraphs you're familiar with have new language in them to make them better and easier to understand and cover more and protect you better. And there's the one new concept is there's a new grid, a 2.5-page grid on the contract where all of the deal points are all in one place. You know, all the deadline right now, all the deadlines are spread out through the form. All of the contingencies are spread out through the form. All the blanks where you put in who's going to pay for this is spread out for the form. All the places like you put, you know, how long do I have for a walkthrough and how long is the offer good for and how long is the escrow and how long do I have to put the deposit in, and all the numbers, they're all spread out through the contract. Now they're all in the same place. So I think, anyway, it's worth thinking. So the point is, end of December, the purchase contract is going to change, as is all the purchase contracts, vacant land, commercial, income property, all the purchase contracts are going to change, plus all the forms that go with the purchase contract, like notice to perform, contingency removal, they're all going to be tweaked as well. So it's all consistent, all the paragraphs, all the references work together. It's all going to happen at once. It's a good thing. I think you're going to like it. I also recommend you take the class though. Thank you, Sandra. And also, we're going to put on free webinars. We did one Monday, 3 days ago. We're not doing one next Monday, but starting the following Monday, we're going to do one 11 to 12 every Monday. Each webinar is going to cover like 2 pages. And it's free and it's going to be recorded. You can go back and look at the one that we already did on Monday. So there's a lot of information. Jody says you guys are going to have classes too. Bill, unfortunately, there's the classes that I teach, that we teach, the CR attorneys teach are not recorded because they're for credit. Jody, right, thanks for answering that. But anyway, it's worth talking about. And obviously, if you have questions on that or anything like that, you can always ask. I'm going to give everyone my email address. So if you have questions on anything I talked about today, or anything else, you can always email me. A couple other things I want to talk about just to wrap this up. What are we getting questions on the hotline about? Well, a lot of the things I've been talking about, we've been getting a lot of questions on the evictions and the raising the rents and the fair housing and the fire hardening defensible space, fair housing. We get a lot of questions on that. You know what else we get a lot of questions on? We get a lot of questions on people getting very creative in their transactions. They're saying things like, my offer is 10,000 more than the next best offer you get. Or my deposit is non-refundable. Or if I don't close on time, I'll pay you a per diem penalty. Or I will pay 10,000 more than the appraised value. People get creative with these things, not realizing that to do what they're trying to do, it has to be written a very specific way. And unless you're an attorney, you really don't know how to phrase it properly to accomplish what you think you're trying to accomplish. What I'm really saying is, I think if you have a buyer who wants to do something like that to make their offer more attractive, either tell them to get an attorney to help them draft their addendum, or you call the legal hotline, talk to one of my attorneys, and we'll make sure you're doing it the right way. Okay? Margot, you're right. I didn't give a Prop 19 update. You didn't miss it. We do have a new Q&A out. By the way, not only do we have a handout, which is not on the website yet, but it will be in a couple days, covering all the new laws like I talked about. We have a specific Q&A on the SB9 that I was talking about. And we have a brand new specific Q&A on Prop 19. First, I'll give you a quick overview, and then you can ask me any questions you have. There is a new law basically clarifying Prop 19, but it doesn't really say anything we didn't think was already true. For example, what's the basic rule? The basic rule is if you're over 55 or severely disabled or the victim of a wildfire, you can now take your current primary residence, sell it, move anywhere in California, and take your property tax with you. So let's say you bought your house a long time ago for $200,000. Now it's worth $1 million, but you're paying property tax based on 200. Now worth $1 million. though. I want to sell and buy something else. If you have $1 million house, it's now worth $1 million. You're paying your current property tax is based on 200,000. You can now sell that $1 million house, buy another house anywhere in California, and take your property tax with you. If the new house you buy, if you sell the old one for $1 million and the new one's worth $1 million or less, you can transfer the property. You will not pay a cent more in property tax. And you can do this 3 times in your life, even if you already did it once in the past under Prop 60. But what if I want to sell my current house I bought for 200, it's worth $1 million, and now I want to buy another one, sell that and buy another one worth 1.1 million? Can I still transfer my property tax to the new house, even though the new one costs more than the old one? Under the old law, you couldn't do that. Now you can. First of all, let me say one thing. There's a built-in inflation factor of 5% a year. You have 2 years to do this. So let's say my house is 200. I bought it for 200, now worth $1 million. I sell it. If I buy another one in the next, I sell it for $1 million. If I buy another one in the next year, I can buy it for up to 5% more than $1 million. I can buy it all the way up to $1.05 million and have no change in my property tax. Or if I wait a whole year and buy this replacement property in the second year, it can cost up to 1.1 million and no change in property tax. But what if I buy the new one before I sell the old one? Well, then you don't get this inflation factor. But what about this? Bought it for 200, now worth $1 million, sell it for $1 million, and buy another one 1.2 million. So even though I don't get that built-in inflation factor, can I still do it? Yes. Well, what will my property tax be on the $1.2 million house I'm about to buy? Well, it's going to be the original 200,000 plus 200,000. Plus the difference between the $1 million sale price of the original and the 1.2 purchase price of the new one. But remember, if I sell first and buy after, the new one can cost 5% more than the sale of the old one with no change in property tax. And if I wait till the second year after, it can cost 10% more. Okay? But if it's more than that, then the difference between the sale price of the original and the purchase price of the new one is going to be added to the property tax basis. Okay? You have to be 55, but only one of the spouses has to be 55. You can actually buy the new one, sell the old one before you're 55, as long as you buy the new one after, or buy the first one before 55 and sell the other one after. Okay? And it took effect April 1st. But even if you did the purchase of the new one or the sale of the old one before April 1st, and you do the second leg after April 1st, you can still take advantage of this. So those are some of the details that were sort of clarified. Ivy's asking, okay, I think you're saying I'm selling my original one, 200, sell it for $1 million, buy buy another one for $1 million. But Ivy, looks like you're saying rent out the original. No, you have to sell the original, right? You have to actually sell it. You can't keep the original one and rent it out. You've actually got to get rid of the original one and actually buy a new one in order to transfer the property tax, okay? You may have heard the negative part of Prop 19, which is true. With the negative is, it used to be you could transfer property to your child or grandchild with no property tax reassessment if it was your primary residence or an additional $1 million worth of real estate. Now that's gone. You can, if you transfer property to your child or grandchild, the only way to avoid reassessment is if it's a primary residence. And it only works as if the child or grandchild also uses it as their primary residence. Plus, there's no extra $1 million worth of real estate you can transfer without a property tax reassessment. Okay, so that's the negative part of Prop 19. Any more questions on that? Those are pretty much the things we're getting questions on the hotline. At least the COVID stuff has died down. That's all we talked about in evictions and COVID for the last year and a half. By the way, what are the COVID rules right now? Well, it depends on where you are. I mean, those PED forms are gone. The limitations on how many people are gone. Standing 6 feet apart is gone. The posted rules of entry, gone, gone, gone. Is there anything related to COVID that I still have to think about when I'm doing my job? Yes. The one thing is the mask. Under California law, if you're outside of your own house and you go into some other public place, like somebody's office or store, restaurant, or you're going to a showing, you're going to see somebody else's house to view it as a showing, or if you're going to an open house, that's considered going into another public place. And if that's what you're doing, if you're unvaccinated, you're supposed to wear a mask. If you are vaccinated, you don't have to wear a mask. Unless, I don't know about you, but LA County has a local rule. And the local rule is when you go into an open house or a showing, you should be wearing a mask, whether you're vaccinated or not. So in other words, some counties are stricter than the state. Plus, of course, the seller of the house or the owner of the office can be as strict as you want. You could say to about your own house, nobody can come into my house without a mask. I don't care about your vaccination status. Or they could say, you can only come in if you're vaccinated, and I want proof that you're vaccinated. That's not the law, but an individual seller or an individual property owner or an office owner or a business owner could have that as their rule. Now, I don't know about you, but the city of LA, where I am, is going to have a new rule come into effect November 1st that says if I want to go to a restaurant in LA, I got to have to prove my vaccination status. Is that rule going to require me to prove my vaccination status if I go into somebody's open house? No. But you know what I mean? Theoretically, a city or a county could do that, okay, if they want to. There's nothing illegal about doing that in California. So I don't, you know better than me if there's any local rules there.
We don't have,
Yes,
we don't have
yeah.
anything local.
yeah. And yes, Drake, of course, yeah, there are exemptions, right? Medical and I think religious exemptions would apply for the state rule as well, and the local rules as well. Heather, bought it for original 200,000. My scenario, I think you're saying is when you bought the house, 200,000, so that's your property tax basis. Now it's worth $1 million. I sell it for $1 million and buy one for 1.5. Is the new property tax based on 200 plus 1.5 minus 1? Exactly right. Heather, you are 100% correct. So it would be basically 700,000. Sandra says San Jose does require a vaccination to enter city-owned facilities. Yeah, there are a lot of local rules out there. Plus, individuals can have their own rules if they want to. And just one more general idea. The rules, there aren't any more of these rules about you have to keep track of who comes in your office and make them sign in and do all that. So you don't have to do all that stuff anymore. However, I mean, if they're unvaccinated, they should be wearing a mask. Of course, you don't have to demand proof if you don't want to. In fact, I guess you don't even have to enforce the rule at all if you don't want to. But what about this situation? You have an office, or it's an open house, or it's a showing. And you happen to be there showing the property, and you find out the next day that someone who was there, either the seller, another agent, or in your office, a client, one of the agents, somebody who was there tells you the next day, guess what? I just tested positive for COVID. Now you think back, oh, well, you were in the office yesterday, weren't you? Yeah, I was. Or you were at that showing yesterday, weren't you? Yeah, I was. You now have an obligation to try to figure out, let's see, was anybody within 6 feet of you for at least 15 minutes when you were here? Because you might have had COVID yesterday. If you tested positive today, you probably had it yesterday. In fact, it's a possibility, like typically a 10-day contagious period. If you happen to be aware that someone there in your office who now is tested positive, so they were there yesterday, so they probably had it yesterday, and you happen to be aware of someone who was in close proximity to this person for a certain length of time, you have an obligation to try to contact that person and say, you were in my office yesterday. One of my agents who you were talking to for a long time is sick. I need to tell you this. Is there a law that I can point you in black and white that says you got to do that? No, but that is going to be the negligence standard. So if you don't do that and the other person finds out that they were in your office talking to some person the other day who is now tested positive within the 10 days after that, if they somehow figure that out, they'll sue you and they'll win. Okay? So just keep that in the back of your mind. Mary, Prop 19. Both, no, good question. You can do one leg of the transaction where nobody's 55. You're 54. As long as the second leg is done, at least one of the people has to be 55. Sandra. So yeah, it's the same question Jody put in there, right? So you see what I said? It's not exactly that.
Oh, I copied
yeah, okay,
Mary's.
right.
Yeah.
Right. Yeah. So
Oh,
yeah,
I see.
So that's the question, Mary. That's the answer, Mary. No, they don't both have to be over 55 to do both sides. Okay. The inflation allowances. So in other words, this is assuming you sell first before you buy the new one, because you can buy the first one before you sell the old one. You got a 2-year period. Assuming you sell first and then buy. You can transfer your current property tax to the new one, even if the new one costs more than the old one, as long as it doesn't cost too much more than the old one. So you sell first. Then within the next year, you buy the replacement. The replacement can be up to 5% more than the sale price of the old one, and you have no increase in property tax. So just using round numbers, you bought it for 200, it's now worth $1 million, you sell it for $1 million. Then after that, you buy the replacement. The replacement can cost up to $1,050,000, and you'll have no change in property tax. Or if you wait a whole year before I buy the replacement can cost up to 1.1 million and no change in property tax. But if it's more than that, if you buy the replacement within the first year after the selling the old one, and you're buying it for more than 5% more than the sale price of the original one, or if you buy it in the second year and it's more than 10%, the difference between the sale price of the original and the purchase price of the new one, you have to add on to the original property tax basis that you've been using. Ivy, couple gets divorced. And Dawn is sort of asking the same question. Yeah, you can't both do it, right? It gets a little complicated. You need to talk to an accountant on that, but in general, they can't both do it, right? Okay. There's some details on that you really need to talk to an accountant about, but that's the general answer. All right. Any more questions? Let's see, look at the Q&A here. I've been looking in chats. Okay. Sandra, single family homes are not subject to just cause. Not anymore. That's the best news I gave you the whole day. Maggie, I'm sorry, good question. 24 square foot minimum lot size before the split. So each one can be 1,200, but the city can say, no, you can't do it unless each one results in a 1,200 square foot. So you put that there, it's 2,400. Don says, I believe you said SB 63 would take effect July 1st. Now you probably know these numbers better than I do. Let me remind myself which one is SB 63.
I think that was the new fire hardening where the
Oh, yeah, right.
local and the state.
If I said July 1st, I was wrong. Sorry about that. There are a couple other laws I mentioned that were July 1st. You're right. That one is January 1st. Yes. Thank you for correcting me there. Sandra, 15-year-old building, 12-month tenant occupancy requirement for just cause. You mentioned doesn't apply to single family homes, duplex, fourplex. In other words, are duplexes exempt? Yes, if it's owner occupied. If the owner occupies the other side. Fourplex, not exempt unless it's newer than 15 years, right? Those are two separate exemptions. Single family homes, always exempt. Owner occupied duplex, always exempt. Rental property newer than 15 years, always exempt, whether it's owner occupied or not. So those are sort of two different things. Shirley, my client sold his primary at 2 million, property tax was $8,700, bought the new at 3 million. In other words, whatever the property tax basis that he currently has, that's causing him to pay an $8,700. I don't know, I can't do the math, but whatever property tax basis translates into $8,700 per year, whatever that number is, just doing it in my mind, it sounds like around 500,000, 600,000. Now he sells it for 2 million. So it sounds like to me he bought it for something like 500, let's say. He's now going to sell it for 2 million. He's buying another one at 3 million. What is his property tax going to be on his new $3 million house? It's going to be based on the original, let's say 500,000 plus $1 million, because there's a difference of $1 million between the sale of the old one and the place of the new one. So I predict that his property tax is going to be based on 1.5 million, which is a lot better than a $3 million basis, but it's not as good as it could be. But that's just the way it is. Rebecca, Jody can help you with that when you're going to have a class on the purchase agreement. Deborah, no, to be very clear, you don't have to worry about just cause when it's a single family home. And you also don't have to worry about just cause if it's not even a single family home or a duplex. It's a multi-unit apartment building under 15 years. So number one, don't worry about single family. Number two, don't worry about owner occupied duplexes. Number three, don't worry about newer apartment buildings. And number four, even if it's an older apartment building, the tenant doesn't get the just cause protection until they've lived there at least a year. Okay? We got a Q&A on this one too. It's called, I think, 1482 California rent control. So yeah, it's kind of complicated figuring that out, but yes, just don't even worry about single family home. There's no risk. You don't need a reason to evict. And if it's owner occupied duplex, you don't need a reason to evict. And if it's a newer building, you don't need a reason to evict. And even if it's older, the just cause protection doesn't kick in until they've been there a year. So you can keep churning tenants, right? You can do 11-month leases, kick them out after the lease. And on, and you'd never have to worry about just cause, but you would have to worry about the rent cap. If the building's over 15 years, it's a rent cap. Okay, back into the chat. Pam, what about the building size? Yeah, there's no particular rules on that one as far as SB 9, as far as, I mean, the only rule is the local government has to allow each side to be at least 800 square feet, okay, on the single split to duplex. So yeah, there's sort of restriction. Mary, you're right. Homeowner can buy property after they turn 53 and sell it. As long as they're within the 2 years, you're right, they can do it. Okay. Sandra, my good friend, always gets the prize for asking the most good questions. Thanks, Sandra. So let me report the rent caps again. It's pretty simple. If you're not under California rent control, it's a single family, it's a new building, it's an owner occupied duplex, you cannot raise the rent more than 10%. That's the statewide cap everywhere, because we are still under a state of emergency for COVID. Okay, what if I'm in under California rent control? Because it's a building that's older than 15 years. What's my rent cap in Santa Clara County? 9%. It's 5% plus inflation. And they've designated the inflationary rate as 4%. Whereas if you're in San Francisco, San Mateo, Contra Costa, it happens to be 3.8. So the maximum that you could increase the rent there in a place under California rent control would be 8.8. So 9 in Santa Clara, 8.8 everywhere else. Of course, I'm assuming you're not in San Francisco or Berkeley or maybe San Jose, where they have a local rent control. LA, for example, you can only increase your rent 3%. So I'm assuming you're not under local rent control. Okay, Ivy, 2,500 square foot. That's talking about the lot, right? So don't confuse the size of the lot with the size of the building. To do a lot split, the lot has to be at least 2,400 square feet. That's not very big. But okay, so I'm not saying the buildings. I'm just saying the two lots that you, in other words, if the lot is already so small, it's only 2,400 square feet, you can't do the lot split here. Okay, so if you do the lot split, if it is more than 2,400, then, very good question. I probably might have not have said this right. The other two don't have to be 1,200, as long as, I'm so sorry. I'm confusing myself. When you do a lot split, yes, each resulting one has to be at least 1,200. So if it's a 2,400 square foot lot, it would have to be 1,200, 1,200. But let's say it's a 2,800 square foot lot. You could do it 60-40. In other words, I don't know exactly what 60% of 2,800 is, but it could be like 15-13. You know what I'm saying? As long as there's not, the resulting lots are both at least 1,200. So you can't, if you're doing this lot split and one of the lots is going to be less than 1,200 square feet, you cannot do it. Or I should say the city doesn't have to allow it. But otherwise they can be up to a 60-40 split as long as both of them are at least 1,200. Okay, thanks for asking that, because I think I didn't say that clearly before. Jane, no. There is no way to retroactively take advantage of Prop 19. In other words, I did say you could do one leg. I'm not sure exactly what you're asking. If you sold the original before April 1st and you buy the new one after April 1st, you're good. Or if you bought the replacement before April 1st and you sell the original after April 1st, you're good. But if you did both of them, the sale and the purchase, you did both of them prior to April 1st of this year, it's not retroactive. You can't do it. Okay? I think that's what you're asking. And I am not seeing any questions.
I think that's everything.
All right. You all got my email address. I put it in there.
I'll put it in one more time just in case.
Jody always knows where the Q&As are, even though I don't know where they are. So she could probably help you with that too. So in that case, everybody, going once, going twice. I'll see.
Just on the RPA thing, you can go to the CAR's website and look under education, and you can see all of the classes that Gov is teaching. Please note those are through CAR, and you will get a test afterwards if you want CEs. If you don't need CEs, you don't need to take the test. It's not required. Let's see, SCORE is also going to be having some classes. Will Che, who was the forms committee chair this last year, will be teaching them at SCORE. We're just working out some details to get those. But I do recommend, as everybody else has said, we do recommend you to take a class.